Number 5. Thank you.
There's nobody here on that.
Okay, we're on the record, this is with the Michigan versus Georgia, Aliyah Woodruff with defendant number 2, in charge with count 1 carjacking, count 2 robbery armed, today's CR438 probable cause conference appearances.
Alexander Kirker on behalf of the people,
Good morning, Your Honor. Ivan Land, P65879, appearing on behalf of Portia Woodruff, who's present on the screen, Your Honor. We have no objection to holding this matter by Zoom. Thank you.
Okay, Ms. Woodruff, can you state your full name for the record, please?
Portia Maya Woodruff.
Discovery issues?
No,
I'm sorry.
Your Honor, no, I don't know. I thought the prosecutors was dismissing this matter, but I don't know. Is that true?
I don't have any information on that.
You don't have any information. Okay. So let's schedule a quick exam then.
Okay, let's see. I have earliest date would be March 7th at 10:30, and then anything after that day.
March 7th is fine.
Okay, at 10:30.
Yes, and I would like to, Your Honor, I would like to put on the record for the prosecutor to check. My client is 8 months pregnant. The alleged victim in this, the alleged suspect in this matter was not pregnant. My client could not have committed this, but I do want to put it on the record. I thought the prosecutor was aware of that. The officer in charge was supposed to inform the prosecutor's office about my client being 8 months pregnant. So I don't know what.
Do you know who the prosecutor is that signed or assigned to this case?
No, I don't. They actually zoomed in on the arraignment date and tried to get the judge at the arraignment to dismiss the matter because she's 8 months pregnant, and the suspect in this case was not pregnant. It was a mistaken identity, and I was informed that it would be dismissed at the PCC, but that's fine. We can appear at the exam, Your Honor.
Well, at the same time, I think maybe you should just talk, if we can get the prosecutor, you have a conversation.
Okay. Try to get it earlier. I'll try to do that, Your Honor.
Okay, so I'll set it for March 7th at 10:30 with the hope that you speak to a prosecutor at the meantime.
Okay, thank you, and nice talking to you and your staff, Your Honor. You have a great day.
You as well.
Thank you. Bye.
Okay.
Gary Foreman. This is people of the state of Michigan versus Gary Foreman. Mr. Foreman, excuse me, case 2355364. Mr. Foreman is charged with count 1, assault with dangerous weapon, felonious assault, count 2, weapons assault, firearms, count 3, weapons, firearms, possession by a felon, count 4, weapons assault, firearms, the habitual offender, third offense notice. Today they set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Maurice Davis, P76203, appearing with Gary Foreman, who's present appearing via Zoom. Mr. Foreman, state your name.
Gary Foreman.
And Attorney Davis, any discovery issues?
I haven't received the discovery yet. This is our first time up, so I'm requesting the discovery, and I want to set another PCC.
Mr. Kirby, do you have any insight on discovery?
No. This is, are you missing paper or digital or both?
Anything that you have, I haven't received anything yet.
So you're requesting another PCC?
Yes, I am.
I don't know how much time needed, so.
It's the next available date.
We can do it tomorrow, but I don't know if we'll have those. Mr. Kirby, do you know if something is readily available?
I think
We set
that's
out, we set out a couple weeks.
That's too far, Mr. Kirby, Davis.
Okay. Well,
Mr. Kirby's checking to see if discovery is available.
okay.
Looks like you should have received the paper discovery on the 22nd, February 22nd.
Attorney Davis, did you hear what Mr. Curtis said?
You said that you sent the discovery?
Yeah, it looks like it was sent on February 22nd, but just in case, I just resent it.
You did, okay.
So with that, are you ready to set an exam date?
Yes,
Okay. I have March 7th and any date after that available.
March 7th.
Well, actually,
March 7th. March
Sorry,
7th is fine.
I meant March 8th, I'm sorry.
Oh, you meant March 8th. Can we do March 10th?
How about you do 9:30 or 10 o'clock?
9:30.
All right, Mr. Foreman, your preliminary examination is set for March 10th at 9:30 in person. You understand that?
Yes, ma'am.
Okay. Anything else?
No, nothing else.
Okay, go ahead and do that.
Thank you.
William Welch,
Yes, ma'am.
Good morning, Your Honor.
good morning. Are you ready for Welch to be called?
We are, Your Honor.
Okay. Case number 2355520. Welch. William Blake Porter Welch is defendant number 2 in charge with 1 count of criminal enterprises conducting, count 2 stolen property receiving and concealing, count 3 attempted larceny from a motor vehicle. And that is it. Today's set for a probable cause conference appearances.
Alexander Kruger on behalf of the people, P86282.
Good morning, Your Honor. Edward Trojanowski appearing on behalf of Mr. Welch, who's appearing via Zoom, waiving his physical presence in the courtroom. I'm standing in for the attorney of record, Jason Malkowitz, with permission, Your Honor.
Okay, Mr. Welch, can you state your name for the record, please?
William Welch.
Good morning.
You-
Any
you're-
discoveries?
Yes, we have discovery, Your Honor. If I may, there is a co-defendant in this matter. I believe his case is set for a probable cause conference on March 10th. We're just asking for an adjournment to that date, Your Honor. I'd like to address bond. I've already advised my client of his right to hold the exam within 21 days, and he's claiming that right.
Okay. I will adjourn it to March 10th to, for the co-defendants to be together. And you said you want to address bond?
Yes, Your Honor. Mr. Welch is currently on not just a tether, a house arrest tether, Your Honor. He works in construction. He has a home that he's been rehabbing. He's building. He recently had bought another one, Your Honor. So he's unable to get to work right now to support his family because he's on house arrest. He has a retained counsel. He's going to come to court. He's already been coming to court. I would ask for the removal of the tether. The co-defendant, who also has gun charges, does not have a tether requirement. I just ask for removal of the house arrest tether, Your Honor.
Anything for the people?
You believe it's the discretion of the court.
One moment. I'm looking, I don't have this ROA. Where is it? I don't see any conditions on his ROA for house arrest. Let's see. Okay, I will, have the tether removed. No, no, that's, oh. No, okay. Give me a moment because this file is giving me the information I need on your client at all.
Okay.
Okay, so I'm reading through the file here. What I'm gonna do, I am gonna keep the tether on, but I'm gonna take off, lift the house arrest, restriction. Based off of the information here, it was 6 pages, I had to read through it. So he's allowed to work, but the tether will stay on. And if there are any complaining witnesses, no contact with the complaining witnesses.
Very well. March 10th. Thank you.
All right, have a good day. Attorney Hayes, good morning. Attorney Hayes, are you ready to, I know you have something else going on. Mr. Welch, you're all set for today. You're coming back on March 10th.
Okay.
Have a good day.
Okay, you too.
I don't know what time.
Good morning, Your Honor. Sorry about that.
How you doing today?
You all, how are you?
Good. So you're not going today.
Correct.
All right. Are you coming in the building at all?
I have to go downtown. I can come to the building if that helps.
We'll be here. So that would be great if you could. If not, then we'll have to figure something out. But I will stay here till you come so I can sign it.
For the writ portion of it, you mean?
Yes, the writ.
All right. Let me see what I can do. I know the support staff is not available this morning. Let me see what I can do. If not today, I will tomorrow, and we can get that taken care of.
Okay, I'm here tomorrow.
Okay, sounds good.
All right, I appreciate it.
Yep, of course. Thank you, Your Honor.
Thank you.
It's Monday.
It is Monday. Outside of Sean Holloway, is anybody ready?
Judge, I have two, I'm sorry, I have two PCCs,
Oh,
more or less.
May it please the court, ready on LaShawn Davis?
you said ready on LaShawn Davis?
Yes, Your Honor.
Okay, after Attorney Pope, I will call your case.
And David Kennedy.
David Kennedy and
It said,
is it two in here?
oh, it should be on. I had it to you already talking. Slide it.
Oh, Sean Holloway.
It-
Those are for an exam.
Sean Holloway is set for an exam. He's here,
Right.
but I have two PCCs and I was told.
Who's the other PCC?
Richard Morlett.
Okay.
and David Kennedy.
I need more lead.
Okay. Here are your.
Thank you.
Oh, no problem.
All right.
So Judge, I don't know, it's my understanding Mr. Morlet is in the Wayne County Jail. I've spoken to him, and I can waive his presence, we send it for an exam, I do know that.
Okay. That's fine. Wait. Richard Morley. This is case 2355566, the people of the state of Michigan versus Richard Morley. Mr. Morley is charged with count 1, robbery armed, serious injury, count 2, assault with intent to do great bodily harm less than murder or by strangulation, count 3, assault with a dangerous weapon, felonious assault with habitual offender force. There's notice today's day set for a probable cause of harm disappearances.
Alexander Kirker on behalf of the people, P86282.
Your Honor, may it please this honorable court, very report on behalf of Richard Morlet. I ask the court to allow me to waive his presence. He's currently in the Wayne County Jail. I had communication with him on last week in reference to my intent to set this matter for an exam.
Okay, you have discovered?
I do.
I can squeeze, he's in custody, I can squeeze him within next week.
The week of the 6th.
Seven. At 11 o'clock.
Yeah, that would be fine. Judge.
Anything else on Roland?
Tell me what his current bond is, Judge. I mean,
I see here, you had a bond determination hearing on the 21st.
yeah,
Yeah, but you have, so instead of 500,000 cash by Judge. You want an ESU order?
yes, please.
That's your free, if I may, he put it 10%, you say cash.
Yeah, I have on your cash on the 17th.
I have 10%, Judge. Well, we may not get it, so,
What date is the cash?
10% on the 21st of February.
Yeah, I don't have it. Okay, I still order the ESU report,
Thank
so
you.
it says 10% in the system. I'll order it. Okay, on Kennedy.
Yes.
Case number 2161344, the people of the state of Michigan versus David Kennedy. Mr. Kennedy is charged with 1 count of weapons carrying concealed, commission of a felony with a motor vehicle advisory. Today is the day set for a probable cause of conspiracy.
Alexander Kirker on behalf of the people, P86282.
Your Honor, may it please this honorable court, very report on behalf of Mr. David Kennedy. Judge, I would ask to waive his presence as well. Unfortunately, I have no way of contacting Mr. Kennedy. I will send out a letter.
Like adjourn, PCC, to find him.
I probably will do that, yes, please.
David Kennedy is on the Zoom.
Mr. Kennedy, can you unmute your device and state your name, please? Thank you, Attorney Murray.
Yeah, I'm here. David Kennedy.
Yeah. Okay, you're in court, sir. A little more decorum, please.
Mr. Kennedy, would you state your name for the record?
David Kennedy.
Okay, any discovery?
I do need discovery, Judge. I do not have it as of yet. So I'd ask for an adjourned PCC, get the discovery, when you come back, and I'll be able to discuss it with Mr. Kennedy.
Okay, you're coming back on the 7th. You want to set down for the 7th?
Yes, please.
Okay. You want to do it at 10:30 since you'll be here at 11?
Yes, that's fine.
Okay. So March 7th at 10:30 for adjourned PCC.
And I need to be able to give Mr. Kennedy my contact, because I don't have his.
Okay, Mr. Kennedy, can you take your attorney's number down, please?
Yeah.
Oh, they. Okay, I think he's waiting.
Oh,
Or you
okay.
want me to do off of YouTube or?
No, that's fine.
Okay.
313-492-3686. Attorney Pope.
Gotcha.
You know,
Got you.
thank you. Call me later, please. Thank you, Judge.
Mr. Kennedy, all set for today. We'll be back on March 7th on Zoom at 10:30.
All right, thank you.
You're welcome. And
I
before we-
will take it.
Huh?
I thought you were getting ready
Oh.
to say that I saw some behavior that I will address.
Yeah, talk to
Absolutely.
I think we can. Okay. We got three more PCTs this week.
All right, that's fine, Judge.
Okay.
Because this is the way.
Oh. This is case 2355352, the people of the state of Michigan versus Sean Holloway. Mr. Holloway is charged with count 1, weapons, firearms, possession by a felon. Count 2, assault with a dangerous weapon, felonious assault. Count 3, police officer assaulting, resisting, and obstructing. Count 4, weapons, felony firearm. Count 5, weapons, felony firearm. Count 6, weapons, felony firearm with the habitual offender report that's been noticed today that set for a preliminary examination appearances.
Alexander Kirk on behalf of the people, 386-282.
Your Honor, may please this honorable court, there is spoke on behalf of Mr. Sean Holloway, who stands to my immediate right. Mr. Holloway, state your name for the record, please.
My real name is Paul Holloway. That's what I was arrested as, Your Honor. I don't know where this Sean coming from, but Sean Holloway, Your Honor.
Okay, and I have on here also known as Paul Martin Holloway as one of your.
When they took my state ID when they arrested me, I have it with me. It's Paul, but whatever the record will reflect, I have you, Sean, as the alias. Your Honor.
Okay. All right, you've used that name, right?
Okay.
Yes.
He said, yes, but
whatever you want me to state for the record, if that's what's on the file, then I'll go with that, but that's not my name.
So I have Sean Holloway, also known as Paul Martin Holloway.
Yes, ma'am.
Okay. And today's date set for a preliminary examination. Is it my understanding that your client, attorney, is going to waive the exam?
Judge, I've had a discussion with my client. He understands that the prosecution and a preliminary exam would have to demonstrate there's probable cause of crime has been committed. Probable cause he has some involvement in that particular crime. With that knowledge, he elected to waive the preliminary exam, send this matter to the Front Working Office of Justice for further proceedings. He understands he will not have a preliminary exam of probable cause here. And as far as I know, Mr. Holloway, no one has provided you with any incentives or forced you to waive your preliminary exam. And you're doing so freely and voluntarily, and you want this exam waived and sent to Front Work.
Thank you, Attorney. Any objections from people?
No objection, Your Honor.
Okay, with that, I will have you gone over, Mr. Holloway, the Third Circuit Court. Your arraignment on the information will be March 13th at 9:05 a.m. And bond CP. Thank you.
Well, Judge, that's all of our business.
Okay.
Staff have a great day.
You as well. Okay, back to Zoom.
Judge, after Mr. Glenn, can you call me for Mr. Franklin, please?
Sure, yes.
Thank you.
Judge, is I'm in the right courtroom?
Yes, Mr. Long. Your Honor, we're ready on Mr. Long as well.
Okay, well, I can only call one at a time, Mr. Long, just hold on.
Okay, I'm waiting on my attorney to come in here. Thank you.
I believe Attorney Quick is your attorney? Is that?
Yes, Your Honor.
correct? Okay. You need to speak to your client at all?
No.
Okay. All right, let's call LaShawn Davis. Case number 2155014, the people of the state of Michigan versus LaShawn Davis. In charge with count 1, concealed, count 2, weapons, firearms, reckless use today except for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
William Glenn, P 36794 on behalf of Mr. Davis. Your Honor, my client is currently in the Wayne County Jail. I've had recent contact with him in the jail. I'm asking the court for permission to waive his presence for today's hearing.
Okay, since you've had contact.
Yes, Your Honor.
Okay, any discovery issues?
No, Your Honor.
Okay, are you looking for a date for exam?
Yes, Your Honor. My client, he currently has another preliminary exam scheduled for March the 8th in front of Judge King at 10:45. So if he could do it sometime after that on March the 8th, that would be good, because me and Mr. Davis will both be in the building.
So I'm guessing 11:30 would be too soon, because that's the last time in the morning.
That's fine. 11:30 is fine.
Okay,
Okay.
so March 8th at 11:30.
Yes, Your Honor. Thank you.
You're welcome. Anything else?
No, Your Honor.
Okay, have a good day. And I need Franklin. Yes, Franklin. Roderick Franklin. Case number 2159765, people of the state of Michigan versus Roderick Franklin. Mr. Franklin is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, felony firearm, with a second offense notice. Count 3, weapons, carrying concealed, this is a habitual offender, of fourth offense notice. And set today for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Alicia Martin, P69003 on behalf of Mr. Franklin. Your Honor, I've spoken with Mr. Franklin as recently as this morning. He's not really adept with using the Zoom, so I would like the court to waive his presence, please. I did receive discovery and would like to set the matter for a preliminary exam.
Okay, so let's see, March. Now is the earliest date at 9:30. I have one open and 11 o'clock. And after that, the dock is pretty wide open.
You said March 10th at what time, Judge?
9:30 or 11.
That doesn't look like a good day for me, Judge. I don't want to push it. Can we go to the following week?
Sure, March 13th, Monday.
Yes, that would be a great day. Can we do maybe 10:30 on that date?
10:30 is fine.
Thank you, Your Honor.
You're welcome. Anything else?
No,
Okay, have a good day.
you too. Thank you.
Ryan, you on?
Ready, Your Honor.
Yes.
Calling case 2355593, the people of the state of Michigan versus Rodney Long Jr. Mr. Long Jr. is charged with count 1, robbery armed, count 2, computers using to commit a crime with a maximum imprisonment of 20 years or more or life, and count 3, larceny, $1,000 or more but less than $20,000. Count 4, weapons, felony firearm. Count 5, weapons, felony firearm. Today set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Rodney Long Jr. Mr. Long is present via Zoom.
Mr. Long, can you state your name for the record, please?
Rodney Long Jr.
Thank you.
Yes, ma'am.
Any discovery issues?
Yes, Your Honor. I've received some paper discovery. I believe there should also be digital discovery. It also appears that there should be return on a forensic phone extraction that we have not received yet. So we would request to adjourn this PCC.
Have any idea how long that might take?
No, Your Honor, I can reach out to the officer in charge and see.
Okay. How about 2 weeks, Attorney Quick?
Yes, Your Honor. That puts us March 7th, is that correct?
March 13th.
March 13th. Yeah, that's fine. Thank you.
Okay, so let's do 9 o'clock.
Very good.
All right, anything else?
No, Your Honor. Mr. Long, please give me a call on the number that I called y'all from last week. Do you still have that number?
Can you give me the number again, please?
Yes. Are you ready to write it down?
Yes, ma'am.
313
Yes, ma'am.
418
Yes, ma'am.
9023.
9023.
Yes, sir.
Okay, thank you. Yes, ma'am. Thank you so much.
Okay, I'll talk to you soon.
All right, thank you. Bye-bye.
And Your Honor, I'm also going to cover the Michael Jones PCC on behalf of Attorney Cody Bradford. He had to step into a trial.
Okay, let me get his file.
Mr. Long, you can log off.
Okay, thank you.
Okay, we are on the record. This is the people of the state of Michigan versus Michael Jones, case number 2355203. Mr. Jones is charged with 1 count of weapons carrying concealed. Today's set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973. I'm standing in for counsel of record Cody Bradford. I believe with Mr. Jones' permission, and Michael Jones is also present via Zoom.
Mr. Jones, please unmute your device and state your name for the record.
My name is Michael Jones.
Thank you. Good morning.
Good morning.
Okay, any issues with discovery?
No, as I understand it, Mr. Bradford has both digital and paper discovery and is ready to schedule this matter for an exam.
Okay.
And I believe if the court has it available, March 9th is a good day for Mr. Bradford.
I have a 9:30 open.
That looks like it should work.
Okay. So Mr. Jones, that means that you are to be here in person on March 9th at 9:30, okay?
Yes, ma'am.
Anything else?
That's all, Your Honor. Thank you.
You're welcome. You'll have a good day.
All right, too.
You as well.
Thanks. Attorney Howley,
Yes, good morning.
good morning. How are you?
I'm well, Judge. How are you?
Pretty good. I didn't really read through all your messages. What's going on?
I apologize, Judge. I'm trying to respond to the clerk. I think there's just been some miscommunication with my keyboard. So my client is Jim Henry Red. We were here on PCC a few weeks ago, Judge. It was set for an in-person exam. I at the time I thought it was set for the 27th, which was today at 10:30. And then I realized yesterday night it was actually set for the 24th. I might have just misheard over Zoom, and he was warranted. We have all the discovery, Judge. I'd just like to set the warrant aside and reset it for exam.
Yes. Yes, I did. Okay. All right. So let's get the date. I'll set aside the warrant.
Thank you, Judge. I appreciate that.
Yeah. What about March 15th or 16th?
Judge, 15th works for me. Whatever time works with the court, mornings is preferred.
10 o'clock,
One more time?
10 o'clock.
10 o'clock's perfect, Judge. Thank you. March 15th at 10 a.m.
What's your client's full name?
Jim Henry Redd, last name R-E-D-D.
Okay, let me make sure the clerk pulls up his name before you log off.
Sure, not a problem.
You got it? Okay, we have it. We'll change it to March 15th at 10 o'clock.
Okay, thank you, Judge. Have a good day.
You too, thank you.
Bye-bye.
Okay, Mr. Boykin, good morning.
Good morning.
You waited on your attorney, correct?
Yes, he said he was gonna be in at 9:15, so I'm just waiting on him.
Okay. It's 9:19.
Okay, I'm gonna text him right quick.
Yeah, just let him know we're ready for him because we're about to start testimony. Good morning. Antonio Gray. Good morning.
Good morning, Your Honor.
How are you today?
Good, you know.
Very good. Okay, can I get, oh. Okay. Morning, Mr. Decker.
Oh, good morning.
How you doing?
All right.
Okay.
Matt,
395. Okay, we are on the record. This is people of the state of Michigan versus Antonio Carlos Craig, case number 2355377. Mr. Craig is charged with count 1, carjacking, count 2, robbery armed, count 3, weapons, felony firearm, count 4, weapons, felony firearm. State they set for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. May it please the court, Berkman Johnson, appearing on behalf of Antonio Carlos Craig, P46646.
Mr. Craig, can you take your full name for the record, please?
Antonio Carlos Craig.
Thank you.
Judge, today is the day the time set for preliminary exam. I've had the opportunity to discuss this matter with my client. We had a chance to review the discovery together and evaluating the same. My client wishes to waive his right to a preliminary exam, understanding that this case will be bound to the circuit court.
Okay, Mr. Craig. Is that correct?
Yes.
Did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you?
No.
Okay. I find your waiver to be freely, understandably, voluntarily given, so I will have you bound over to Third Circuit Court. Mr. in custody will be 1 week from today. That will be March 6th at 9:00 a.m. Anything else?
Yes, Judge, I'd like to address bond.
Go ahead.
Yes, Your Honor. Obviously, this case is court is well aware it's a capital offense, carjacking, and nobody likes carjacking, but my client, this has no prior felony record. I've reviewed the facts with him. This is an isolated incident, and it's very unfortunate. Nobody was harmed, and you know, Judge, I've talked to his parents. He actually comes from a good background. Like I said, I think it's an isolated incident. Very, very, very unfortunate because of the serious nature of the charge But I would indicate to the court that he is not a flight risk. I've talked to his parents. They've been very cooperative. He's been a very cooperative client. He doesn't seem to have malice in his heart or anything of that sort. He's waived his exam. He knows he has to take responsibility for his actions. Because of his background and because of his lack of any criminal history, I think this is an isolated incident, and I don't think it poses a danger to the community. If in fact he's a +1 low risk, if in fact this court was to follow the recommendation, we're just asking the court to add 10% as well as the GPS tether and whatever other conditions this court finds appropriate.
Anything from the people?
Given the seriousness of the charges, the people that asked that bond remain the same, or if there are any changes made to bond, insist on no contact with the victim.
Okay.
Judge, I would just add one thing. In situations like this, even on the state, federal level that I deal heavily in, I think it also gives the court and pretrial services as well as probation and the circuit court judge an opportunity to see how this young man can carry himself during the pending of this case. And that's why in certain instances like this, Judge, I really encourage and hope to get my client on some sort of pretrial release so he can demonstrate to the court and to the other parties involved in the case that he can rehabilitate himself.
Okay, so I will adopt the recommendations, but add one condition: if he were to post with the 20,000, 10% post bond, it should be a house arrest.
Okay. Okay, yeah.
And of course, no contact with the complainant.
Yes.
All right, anything else?
Nothing further.
All right.
Thank you very much, Judge, for the consideration.
I'll call you there.
Do I need to sign anything, Judge? No.
Waiver form, right?
Okay.
Yeah, I'm on, have a good one.
You too, Judge. Thank you.
Okay, are we? I'm in one downstairs too, but.
Oh. Attorney Harris?
Yes.
Attorney Hayes logged on. So the writ that he sent over to the court for me to physically sign, I still have not received. I've checked the mailbox every day. So he's coming over in person today or tomorrow for me to sign the writ to have Mr. Flint writ it out for a date. We don't have the date yet. Of course, we have to agree with Attorney Hayes on the date, but he's gonna come over physically to have me sign it because it's just I don't know what the problem is. We can't get him printed out.
Okay. Okay, so do you want me to come back on for a date?
Can you come back? Well, you have Attorney Hayes' number, correct?
Yes, I do.
Can you just talk to him, Wednesday? And you all agree on the date, you all can log in sometime this week, and I'll set the date.
I'll call him then.
Okay. Thank you.
Thank you.
All right.
Yeah. Perkins not here. You saw Perkins?
Okay, we're on the record. This is the state of Michigan versus Alex Craig Evans, 2355357. Mr. Evans is charged with one kind of robbery armed set for an exam today with an habitual offender force defense notice. Harrison?
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor, Neighborhood Defender Service of Detroit by Natalie Phelps, P83355. I'm here now on behalf of Mr. Evans, who's also present in the courtroom. Mr. Evans, can you please state your name for the record?
Alex F.
Good morning. My party ready to proceed today?
People are not, Your Honor. Sorry, I'm saying there's no witness here.
Your Honor, the defense of the
Okay, well, the exam set for 9:30, 9:42. There's no complaining witness. The the people who cannot move forward, I will dismiss.
Thank you, Judge.
You're welcome. Anything else? Nothing further.
You vote.
Attorney Greenwood,
Yes.
good morning.
Good morning. I have Boykin.
Oh, yeah, we know.
Yeah, I'm sorry. I was in on the old docket with Judge Robbins. I didn't realize we had you.
You need to speak to your client?
Oh no.
Okay, let me see who this gentleman is who's checked in from the Wayne County Jail, and I'll call your case.
Okay, no problem.
In the Wayne County Jail, can you state your name, please?
Richard Arbery Morlett.
Okay, Mr. Morlett, Attorney Polk handled your case. He waived your presence as I did. He said he's spoken with you and he visited you. And we set a date for your preliminary examination. Let me get that date for you. Hold on 1 second. For Mr. Morlett.
You gave an exam.
7?
Yes, at 11 a.m.
Okay. All right, so Mr. Morlett, your preliminary examination will be March 7th at 11 a.m. in person. So we'll have you written out so that you'll be brought over for an in-person exam with your attorney, Larry Polk, okay?
Okay.
Any questions about that?
No, ma'am.
Okay, you're all set for today, Mr. Morlett.
Yeah.
Thank you, Your Honor. That's all we have for you.
All right, thank you.
Worthington?
Okay, Mr. Boykin?
Yes, I lost.
Yes, calling case 2260312 is the people of the state of Michigan versus Stephen Earl Boykin. Mr. Boykin is charged with 1 count of weapons carrying concealed. Today's the day set for a probable cause conference. Appearances?
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Attorney Greenwood?
Oh yes. Emmett Greenwood on behalf of defendant P56556.
And Mr. Boykin, can you state your full name for the record, please?
Stephen Earl Boykin.
Thank you. Attorney Greenwood, do you have discovery?
Oh yes, I have complete discovery.
Okay, are you ready to set the exam date?
Yes, ma'am.
And Mr. Greenwood, if you could reach out to the prosecutor, me, after this exam, I have something to discuss with you about this case.
Okay. Can you put your email in the chat?
Both my email and phone number are on the State Bar website.
Oh. Can you just put it in the chat?
I'll do it. 1 second, hold on.
Oh, I got it.
Okay, you got it, Attorney Greenwood?
Yes, ma'am.
Okay. All right, so we have March 13th as the earliest date. And anything after that is open.
The 13th is fine.
Okay. How about 9:30?
Can we do it like at 10?
Yeah, we can do it at 10.
So 3/13 at 10. All right, Mr. Decker, I'm about to email you. Let me finish copying.
I'll get back to you this afternoon.
Okay. Mr. Decker at Wednesday. Okay, thank you, Judge.
You're welcome. You have a good day.
You too now.
So that's it.
Yeah, we're done, Mr. Boykins.
Okay, I'm about to call you.
Okay.
Attorney Mitchell,
Good morning.
good morning. You ready to call your client's case?
Yes, I am.
All right, this is case 23-55536, people of the state of Michigan versus DeAndre Laron Ellis. Mr. Ellis is charged with count 1, police officer assaulting, resisting, and or obstructing, causing injury. Count 2, police officer assaulting, resisting, and or obstructing, causing injury. Today's date set for a probable cause conference hearings. Actually, the prosecutor stepped down the hallway to get ready for the exam set for 10 o'clock. So can you put your appearance on?
May it please his most honorable court, Rena Mitchell appearing on behalf of Mr. Ellis. Mr. Ellis is incarcerated in the Wayne County Jail.
Okay. And Mr.
We're just
Decker?
gonna actually set it for a live prelim.
Okay. Mr. Decker, since you're here, I forgot.
It's all good.
Can you put your appearance on Mr. Ellis' case?
Yeah, right now. Okay. I didn't say it. Yeah, P8. Good morning, Your Honor. Eric Decker, P8 5931 for the people.
Thank you.
You're welcome.
And Attorney Mitchell, you have discovery, correct?
I'm not sure if I have it on this one. If I'll double check and contact the prosecutor if I don't have it. He has another matter that I'm dealing with him in front of Judge Thomas. So this is a new one. This is like the third one. So he has a lot going on.
Okay. So let's see. March 14th, is that too far out for you?
Hold on, let me check. Nope, that's a good. It's the 14th. What about the 15th? Can we do the 15th?
15th works. I have let's see it, 10 o'clock, 10:30.
Okay, 10 o'clock works. Yeah.
Okay. All right, so we'll set it for March 15th at 10 o'clock.
Thank you.
You're welcome. Anything else from either party?
Nothing further on behalf of my client.
All right, you have a good day.
You too.
Sure.
Ready, I got? And we're on the record. This is case number 2158743. The people of the state of Michigan versus Michael Edward Yacht. Mr. Yacht is charged with count 1, operating while intoxicated. This is the third offense notice felony. Count 2, operating license suspended or revoked denied as a misdemeanor. This is a habitual offender report. Offense notice today's date set for a preliminary examination. Appearances.
Alexander Kirker on behalf of the people, P86282.
D-Todd Williams appearing on behalf of Mr. Yacht, E52845.
And Mr. Yacht, can you state your full name for the record, please?
Michael Edward Yacht.
And who are you?
Morning.
Our parties ready to proceed.
People are not, Your Honor, it's my understanding necessary witnesses are not present at this time.
Anything from the bench?
Your Honor, I make a motion to dismiss.
Okay, time is 10:17. The exam is set for 10 o'clock. People are not ready to proceed. I will dismiss without prejudice.
Thank you, Your Honor.
You're welcome. Do you have a form? If it's, we haven't started yet, I'll do it.
Yep. Just the name.
Oh.
You can wait outside for me. Yeah, go ahead. These guys got it down to a science, Mr. Yacht. Your Honor, may I approach? But I'm glad.
Okay, again.
Yeah.
No, this is so good.
I need that. Oh, yeah, I need that. Yeah, I yeah, you do. And that's what I told you.
Yep. I was always there. He had no idea I was like a Superman.
So cool. Now, where did you?
So I'm in the middle of my brother. We all went to college.
Yeah.
Okay, thank you.
And true. And so. Yeah. And I think it's great. No. Right. the rain. Coming to this one. And that's up for a while. And really, we triggered that. Got all the triggered the rhythm. If you do the same. It's just like, you know, still you have to accept sibling. That's all right. Not your group. So. Shut.
Right. Mr. Kirker, is this your case or them?
It was triggers, but just like.
Wait, we give them the email. Yeah, that's. Okay. From the record, this is people state of Michigan versus Calvin Worthington, 2355108. Mr. Worthington is charged with count 1, assault with intent to murder, count 2, felony, weapons, felony, firearm, count 3, assault with intent to do great bodily harm less than murder or by strangulation, count 4, weapons, felony, firearm, count 5, assault with a dangerous weapon, felony assault, count 6, weapons, felony, firearm, count 7, weapons, firearms, possession by a felon, count 8, weapons, felony, firearm, count 9, weapons, ammunition, possession by a felon. Count 10, weapons, felony, firearms. This is an official offender course offense notice, and today is the day set for a preliminary examination appearance.
Alexander Kirker on behalf of the vehicle P8632.
Good morning, Your Honor. Good morning to your staff. May it please the Honorable Court. My name is Tom Wilson, purpose P55623, appearing on behalf of Mr. Worthington, who stands to my right. I would make a mutual sequestration for any and all witnesses if the prosecution is asking for an exception for the officer in charge. We don't have any contention.
For the record, there's no one in the courtroom other than staff, defense attorney, prosecutor, the defendant, anyone who is on YouTube who may be a witness on this case. Now it's time for you to log off. Any other preliminary matters?
No, maybe we can be seated.
Oh, sure, yeah. Okay, Mr. Kirk, you call your first witness?
Well, Your Honor, at this time, after speaking with the officer in charge, we'd be asking for an adjournment of this exam. The necessary witnesses, to my understanding, have not been cooperative in this case. And so we ask for an adjournment for time to get a witness detained.
Is officer charging?
He was, he stepped out.
Yeah. Before he goes out, what I would ask for the counsel, or the questions that I would have, number one is, has the individual been served? If it hasn't, this is no quicker way to a dismissal. What I would be asking for. Oh, I'm so sorry. Can I go? Yeah, it's okay. Okay. May it please the court, Your Honor, what I would be asking, or just to draw questions that I would be focused on, is number one, as an individual could serve the complaining witness, and if so, I'd like to make an inquiry and then follow. Okay. Thank you.
You know, Mr. Kirk, you probably losing your case. So I'll let you go in the hallway and so come back in whatever you have.
Yeah. Thank you, Your Honor.
Mr. Decker,
Yeah.
are you on this case?
Which one?
Mr. Worthing.
I can't. But hold on just one second. I told Mr. Kirk told me something and then we can proceed. Yeah, I can. When I usually speak pretty, unfortunately, very loud anyways. I hear you. I'm always told that I'm quite loud. Sure, it's on. All right, all right. But I can, yeah, I'll do work.
Okay, you put your parents.
Good morning, Your Honor, Eric Decker, P8593, for the people.
And I asked Mr. Director to bring the officer in charge to speak to play with that.
Yes. From what I understand, from what I've been told by the OIC here, the complaining witness, the person who is actually the victim of the shooting in this case, has had a bit of a long, has had quite a few complications as a result of his of what happened to him. My understanding is that at one point he was on a ventilator and was not able to speak. Now he is in a nursing home, and right now the officer in charge gives me the impression that we will be able to get that we will possibly be able to get the victim in this shooting ready to go. Do you think maybe a week?
Can I have the officer in charge speak?
Yes, please. So, Your Honor, I wouldn't be able to get this done next week. I can get it in line this week or sometime later in March.
Can you put your name on the record too?
Yes, ma'am. Officer Brandon Yu.
Okay, what do you mean get together? What's going on?
So this week, if I'm able to get what I need, I can go talk to both of the managers of the establishment and the owner and get them in line for this.
That's a separate thing. What we would like, the best thing that we think that would be the best is to have the victim actually able to testify. However, if that is not possible, we would then arrange a witness detainer for the owner of the store and the other employee of the store in order to get them in down here and have them testify in the case.
Okay, so planning with reserve.
Yes, to the best of my knowledge. Yes.
But he is in a nursing home, and it's obviously it's a kind of a there's obstacles for him to actually.
Your Honor, he did inquire if he could do something over Zoom when I did get a statement from him, just because he wasn't really able to move around too much. This was a few months ago that I did talk to him, so something could have changed from that time forward. Like I said, he has had a lot of complications.
Medical complications?
I wouldn't say mental, physical.
No, I mean medical.
Oh, mental, yeah, yeah.
All right, Frank,
Yeah.
Stand up.
Yes, may it please the court. My information is, Your Honor, this man is out here walking around in the world. My information is that, well, to that extent that the officer in charge indicated to the best of his knowledge that he's been served. He's not definitively, he should be placed under oath as we are officers of the court. I think when we speak, we're authorized to speak the truth. And I'm not saying that the officer in charge is not speaking the truth, but there has to have some context, some background, and some weight behind it. So he should be placed under oath to the extent that he's making representations to the court that this individual has been served. So what you hear is probably, maybe, I took those words specifically out of the mouths of the attorney who spoke on behalf of the state of Michigan and also the officer. This is a case that should not have been brought right now. So this is a case that everything that they're telling me seems right to the fact that it should be dismissed, and then they bring this case back when they're ready to bring it back. But this individual right here, Mr. Berman, has sat patiently, has sat on $1 million bond in a situation which I believe is completely defensible. But again, it doesn't sound to me that, well, there was no representation that the owners of the business have been served, which is, I think, a separate matter. I don't know what separate matter that may be. I don't know the theory of the prosecution other than the reports. The officer, furthermore, we've had several hearings about discovery. And the officer indicates, and so I've had two tranches, and recently I've had some video disbursement to me of the actual event, of the search warrant, and I believe the arrest of Mr. Worthington, which happened several months after the actual claimed incident. But in this situation, he's indicated that he's spoken and taken a statement from the individual. I don't have that statement. There's no indication in any of these reports that I have that statement. So again, I'm asking, I'm pressing this court to dismiss this matter without prejudice. When the people are ready to bring this case, they know how to get in touch with Mr. Worthington. He's not going to change his address. He still has some other matters to deal with in another jurisdiction. But allow him to get on with his life and not be subjected to maybe and possibly in this week or next week. I think that's the only fair result out of this. Now, whether those individuals are subject to any detention or order of detention, they can always do that under a miscellaneous number and have that ready to go or teed up, as I think they're indicating, having it ready for the next opportunity in which they might decide to charge Mr. Worthington again.
Okay, my question is, so you mentioned a witness detained.
Okay.
For his unwillingness to cooperate and also medical issues, means that he's saying that he's not here because of medical issues. Which one is it?
Okay, that is two separate witnesses. The complaining witness is willing to participate. We need no detainer for that. That's the reason why I mentioned that one first, because to me, I think that is the that's the best way to go.
He is the one who is just medically, physically unable to be here.
Yeah, he's been he was in the hospital, and what I heard from the officer in charge is he was in the hospital. The report that I had that I was handed on Friday said that he was unable to speak. I learned this morning from the officer in charge that actually he's been moved over to a convalescence home and his treatment does continue. But I'd also like to make a further point, is that this case took some work. There were 4 search warrants before we were able to, before the people were able to get in contact or detain the defendant. So there were 4 search warrants that were there. It took some time to do, and also considering the complaining witness has had a very long road to recovery, has made this case more complicated. Now, in the event that, let's just say, but the reason why I brought up the witness detainer is because in the event that the complaining witness who is willing to participate, maybe his health takes a turn for the worse and he all of a sudden can't appear. The reason why I brought up the witness detainer is simply because there's other witnesses that we could get here with the detainer in the event that his medical circumstances make it that he cannot be here.
Okay, Officer Aliyah, I'm going to swear you. You swear to tell the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Okay. The complaining witness, that's who I want to speak about, or talk about. The Dominic Henderson, correct?
Correct.
Do you know where he is and what his medical state is right now?
His current status of today, I do not know, and I do not know where he's at today.
When's the last time you or any of your officers had contact?
This would have been October, November of last year. It would have been time stamped on my statement.
And so, Mr. Decker, where's the information coming in from a nursing home?
He told me about the nursing home this morning. Was that he said that was the last time that he spoke.
That'll be November, October, November.
Correct.
Yeah, he wasn't moving at that time. He wasn't like walking around or anything like that. And he was at a full-time care facility or whatever.
Mr. Decker, has anyone had contact with Mr. Henderson in the last month?
In the last month, no, I'm not aware of.
How was he served?
The subpoena would have went to my supervisor since I'm no longer in that particular unit. So I wouldn't personally get him. They would have went to Sergeant Collins and he would have served.
Sergeant Collins is available to tell us where he is. Or where he was when he served them or how he served them.
I'm sure he could testify or chime in on where or who he had served. But I did not physically serve.
Anything else from the people? trying to understand what we're trying to do this is and why.
Okay. Nothing further from us, ma'am.
Yeah.
Just briefly, Your Honor, although 4 search warrants have been served, they're still not ready today. We've been back on 3 or 4 occasions regarding discovery. I still don't have that statement today. I don't know, and I think that it's safe to assume that we don't have anything definitive on this record that this individual has actually been served. Because this officer, upon further questioning, has indicated that he can't make that representation. He's only making a representation by the processes that work internally within the Detroit Police Department. That's not sufficient for testimony to say that that individual has been served. And to see a detainer against someone who has not been served, and there's been no representation that other witnesses have been served and failed to appear. So to seek a detainer is sort of a draconian, and I think it's an inappropriate use of a detainer. So at this time, everything that has been spoken from the government screams of a dismissal without prejudice, and they can always return. They have a statute of limitations of 6 years on this particular matter. But just as important is that I say that this individual, not because I met this individual complaining witness, but what I'm indicating from witnesses that I've spoken to, this individual is very active on Facebook. Very active on Facebook, not necessarily about this case, but just he's on Facebook.
Somewhere present.
Somewhere present and somewhere actively communicating, whether he's able to orate that, I'm sorry. Whether he's able to orate that or whether he's ready to type that. But nonetheless, he's communicating. So he has some function, and it seems as though the function is fairly active based upon what hearing from other individuals. So I would renew my request for dismissal without prejudice.
Okay, so this is what I'm going to do. Based off of the nature of charges, Attorney Perkins, I did allow for adjournment for this case for defense counsel for other reasons. I am willing to adjourn for 48 hours to Wednesday, if that day works for you, and allow you to address bond.
Well, you can take more time than that. Well, I'd ask for, because here's the reality. If they're gonna recharge it, I like to deal with it as it goes on, but I'd ask for a personal bond. I mean, this is an individual who's been in custody now a month and a half since January 9th. So I think that, there's no indication that he has any, in my understanding, in my review of his prior history, that he has any history of flight. So this is a situation in which I think it's a defensible matter, but I won't speak as to the elements or the circumstances of the events of July 16th. But again, I'd ask the court for a personal bond. Court can make a determination from there. But as the court may recall, the only reason why we requested an adjournment was because we did get the discovery, and we still don't have it today. But officers indicated that he took a statement from him, and it should be timestamped at the date and time where the statement is. I still don't have it today. So to hold it against Mr. Worthington and not grant him a dismissal, I think the prosecution is not in proper stead to do that. But the court is in its own proper stead to make a determination as to what you would like to do. But I say all those things and ask the court for a decision.
My issue is that I don't have a clear answer to what the fighting witness wants to do because they haven't contacted the person that is fighting witness. So I don't want to dismiss this case today based off of him not being contacted since October or November when he wants to come forward. I don't know if it's subpoenaed or not. That person's not here to say. So what I want to do, I will adjourn this matter for 48 hours or 72 or however many hours days you need Attorney Perkins to come back. Mr. Deputy.
Yeah. I'd like to address the discovery issue that Mr. Perkins is talking about. I am not aware. I don't know if the officer that took the statement in the hospital was wearing body worn camera at the time. I don't know.
The officer charged us said he took a statement over the phone.
He took a statement that I don't know about.
No,
go ahead.
just to elaborate on that. I took a statement in person at the nursing home. This was I'd say roughly 3 months after he was able to talk now, getting out of the hospital. This is a full-time care facility on 80. So I did take a statement face to face with him on paper. His signature is on the statement. Everything was sent over to the prosecuting attorney's office who signed the warrant.
And again, I feel like I'm wasting Mr. Worthington's time by asking for more time for adjournments because of the discovery. I'm looking at the discovery pack that I received as the most recent. There is no statement in there. And again, the very reason for them not to, the perspective, the fact that they cannot represent an individual who's been served is the very reason why dismissal is merited and almost mandated because they're not prepared and ready to go. They don't even have the other witnesses to start this in particular, because here's the rule. The rule is you can start in part or, but the thing is, most oftentimes they dismiss when they don't have the absolutely necessary witness, but sometimes when they have these issues, they'll start with something. So the rule is that they're ready to start. So they're not even ready to start. They're not even ready to represent that they even got the other individuals served to come down here, whoever those other individuals are. I think you indicated the bar owners in that particular matter that I can go out and look at it. That's the very basis and precipice of why a dismissal is merited in this situation. They don't know. And to wax philosophical on what the position of the complaining witness is, I think is irrelevant. It's the fact that the government is not ready to proceed, and that's why the dismissal is merited. They can clearly go recharge. Oftentimes, what do they do when you dismiss a murder case? They go recharge him as soon as he walks out the door, and that's fine too. But today, I think that they have not made those representations. They've not even brought in the individual who was responsible for serving the subpoenas, and that's the reason why. Not this young officer here, officer in charge here, who no longer works in that unit. So that's the reason why I make that request.
Officer, will you be the person to adjourn to serve the complaining witness?
Yes, ma'am. I will make sure that everything is taken care of. You're not involved.
I'm still only allowing 48 hours.
That's fine, Your Honor. If I may add, I don't know the other witness we have from Aber, but he will be here towards the end of this week. We can go forward with that.
I don't know.
That was
I don't know your plan.
the evidence tag is
Okay.
what he's speaking of, and no, we can go forward with that.
Okay, Mr. Decker, you want to put your, I'm sure it's an objection to the bond motion on the record.
Yes, Your Honor. I mean, it's obviously with the seriousness of the charges, we would object to a reduction in bond. It seems as though, especially considering that it's a 48-hour adjournment, it seems like we could just that it doesn't seem like it's a good idea based on the seriousness of the charges and considering it's 48 hours anyway. I think it's not necessary to reduce bond at this time.
I don't like people sitting in custody waiting for exam because things aren't prepared and ready to go.
Okay, well, I mean, how about we would hope that at least there would be some kind of a GPS tether or some way to make sure that we could, that we'd have at least some control.
Knowledge of where it is.
Yes, knowledge of where it is, yes. Thank you.
I will adjust bond. I am going to change it to a personal bond with the tether. Mr. Worthington, I would normally get into the discussion about employment, whether you go places, but we're coming back in 48 hours. So I'm going to put you on house arrest until we come back in 2 days or whatever day we agree on. So it'll be a personal, and I'm just going to keep the $1 million on there, but it's a personal bond. So you should be able to get a tether by the time we come back. And
Not really. Not really sure.
killer is.
No, that's fine. I mean, what Mr. Decker's request was, to the extent the case is gonna go on, I think he's right in asking for some ability to maintain his location.
And no contact with the complaining witness, no contact with the location, Teresa. No indirect contact with anyone involved in this case, no social media. Just stay quiet when it comes to this case.
Yes.
Okay. And I will fill out the form and put a note on there that, what day are we?
Wednesday.
Wednesday?
Wednesday's fine.
Okay, does 11 o'clock work?
Yes.
if you have a stable residence to go to?
His mother was down here, but she came down at 8:30 and didn't realize that we couldn't come into the courthouse. I went to the tell.
Oh.
Yeah.
I will put your mother's house as long as the bond adjustment, okay?
Yes, ma'am.
Okay, anything else?
No, Your Honor.
Okay, so Officer Ely, you have the task. You understand what it is. We'll be back here March 1st at 11 o'clock.
Thank you, Your Honor. Thank you. Okay. You're welcome. Pencil back.
Thank you, Mr. President.
With the little.
How you doing? All right, so Monday.
Cold, sleepy, raining ice. It's icy out already. I was walking like this.
You have the record of the people of State of Michigan versus John Brandon Baxter, 2355408. Mr. Baxter is charged with one count of stolen property, receiving and concealing a motor vehicle set for a preliminary examination. Today,
I'm gonna agree on that with people P868282.
And good morning, Tiffany Hall on behalf of Mr. Baxter, P79667.
and Mr. Baxter, please state your full name for the record, please.
Javon Brandon Baxter.
Good morning to you. And Mr. Kirker, you did send an email, I don't remember the date, requesting an adjournment because your officers are on furlough, is that correct?
Yes, Your Honor, it was sent on February 16th.
Okay. You have objection to that request?
Judge, I do, but I understand it's furlough and typically court respect that.
I do find it because, um, we did discuss a date in the event that I read the adjournment, so it's at March 9th at 9:30.
Yes.
Okay. All right, so let's see, Mr. Baxter, you're gonna be adjourned, so because the officer is on furlough, so we'll be back here on March 9th in person at 9:30, okay?
And also, Judge, I did receive his discovery, but when I also with Dia, I didn't see that.
Thank you.
Okay,
Thank you.
all right, anything else?
No, that was it.
Okay, you all have a good day. Good morning, Attorney Dunn.
Good morning. Hey, I have Isaiah Patrick today, you guys, and it was supposed to be a live exam, but after talking to my, he wants to waive his exam this morning with the prosecutor's permission. It's a case that involves police officers, so I don't think there'll be an objection.
No objection.
Okay. And Your Honor, he didn't have transportation, so I took the liberty of telling him we can do it by Zoom. I hope that's okay.
That's fine.
Thank you. He should be on. I just texted him. He was trying to zoom into Frank Murphy. I had to tell him, no, Judge Sabree, 36. So he should be here momentarily.
Okay. Do I have your permission to sign your name on the waiver?
Yes, ma'am.
Okay.
Okay, he says he's in the waiting room.
He might be in my brother's another courtroom. He should be in court. Can you give him the Zoom information? Because my brother's is 436, so he might be in the other Judge Sabree's court.
Oh, he did just say Adam Sabree. Let me see.
Yeah.
I'm sorry, what's your first name again, Judge Sabree?
Aliyah.
Aliyah, okay. He says, okay, thanks. So I think he's coming in.
Mr. Patrick, good morning.
Good morning, Your Honor.
Okay. Okay, we're on the record that the people of the state of Michigan versus Isaiah Trayvon Patrick, 2355478. Mr. Patrick is charged with count 1, stolen property, receiving and concealing a motor vehicle, and count 2, police officer assaulting, resisting, and or obstructing. Mr. Patrick is defendant number 1. Today's the day set for a preliminary examination. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Susan Dunn, P58696 on behalf of the defendant.
And Mr. Patrick, can you state your name for the record, please?
Isaiah Trayvon Patrick.
Thank you. And Attorney Dunn, is it correct your client wishes to waive his preliminary exam today?
That's correct, Judge.
Okay. Mr. Patrick, I'm going to ask you a series of questions. If you don't understand them, please just ask me to repeat them, okay?
Yes, Your Honor.
Okay. Is it your wish to waive your preliminary exam today?
Yes, Your Honor.
You understand you have a right to a preliminary exam?
Yes.
And that if you were to demand that exam today, the people will have to show at the probable cause standard, not the beyond a reasonable doubt standard, but a much lower standard, probable cause standard, that the charges that I just read off were committed in the city of Detroit and that you probably committed that crime.
Yes, Your Honor.
Okay. And knowing that information, do you still wish to waive your preliminary examination?
Yes, Your Honor.
Okay. Did anyone force you or threaten you to waive your exam?
No, Your Honor.
Okay. Did anyone promise you anything in exchange for you to waive your exam?
No, Your Honor.
Any objection from the people?
No objection from the people.
Okay, Mr. Patrick, I find your waiver to be freely, understandably, and voluntarily given, so I will have you bound over to Frank Murphy Hall of Justice, 3rd Circuit Court for an arraignment on the information dated March 13th at 9:00 a.m.
Thank you, Your Honor.
Thank you, Judge.
Also, Attorney Dunn, do I have, well, I guess I should ask Mr. Patrick, I have to sign, do I have your permission to sign your name, Mr. Patrick, on the waiver form?
Yes.
Okay.
And-
All right.
Is it March 13th you had said?
Yes, March 13th, so 2 weeks from today.
All right, thank you.
You're welcome.
Thank you, Judge.
Thank you. You have a good day.
You too. Drive safe. It's bad out there.
I heard. Thank you.